Good morning, everyone. This is Tony Larimore, and I'm the project director for the Multidisciplinary Responses to Families and Communities in Complex Homicide Cases Technical Assistance Grant. And thanks so much for signing on for this webinar. I think for most of us on the East Coast, it's 10 a.m., but I think for one of our sites, it's a little bit earlier. So thanks so much for waking up early and joining with us to learn today. Today we'll be hearing from Jane Anderson with Equitas, and I will let her take it away from there.
Thanks, Tony. It is a pleasure to be here this morning. I'll join your site. That's the early morning. I'm calling from San Francisco, so we're having a beautiful day here today, so I'm not too upset about that. So today we're going to talk about community healing and really the sort of trauma-informed witness response in homicide cases, and that it can include victim witnesses as well. And we'll look at this as a way to really hopefully improve participation, safety, and uphold victims' rights at the same time. I'm an attorney advisor with Equitas. Equitas is an organization funded mostly from the Department of Justice, and we provide support and training and technical assistance to prosecutors and allied professionals that are working within the criminal justice system on any range of issues. There's an emphasis on violence against women and witness intimidation, and we'll be talking a lot about that today. We're available 24/7 via telephone and email. We provide everything from case consultations to identification of expert witnesses that might be pertinent to your cases. And then we provide trainings via webinar like today, but also larger scale in-person trainings. And then we publish a lot of resources, and I'll actually have a list of those at the end of the presentation that will be relevant to what we're talking about today. So a lot of what we do is we try to take from a lot of the research and best practices out there and share that with you, and we do that under our fair use rates. So I am Jane Anderson, and I'm a former prosecutor myself. I've been with Equitas for just short of 4 years. And prior to that, I was a prosecutor in Miami-Dade County. We're a large jurisdiction, and we have about 250 attorneys. And throughout my career there, I prosecuted everything from misdemeanor domestic violence to homicide to drug trafficking to kidnappings, and I ended my career co-founding their human trafficking unit. So I have a wide breadth of experience, and hopefully I can share some of that with you today, including, a lot of the challenges that I'm sure you guys are facing and that we also had issues with in Miami. So what we'll really focus on today is that we'll be trying to look at ways to encourage witness participation within the criminal justice system. And we'll look at the causes of why there is a lack of participation, and then how can we address that, and then how can we move forward even when we perhaps don't have participating witnesses. And really all of this takes a coordinated effort, and that's not just lip service, but the prosecution efforts are only effective when we have the key support of both our law enforcement and our service providers and advocates, amongst others that are within our communities that are really building this response that's definitely needed when we're talking about complex homicides. And ultimately what we know of as one of the major challenges is witness intimidation, witness tampering. And we'll spend some time talking about, okay, how can we really strategize to both limit how that intimidation can affect our cases, but then also respond to it when it does happen. So let me take a quick poll from you guys today, and let me ask who is online participating today. We've got a couple of choices here on the left: prosecutor, law enforcement, systems-based. And I think it doesn't look like a poll's popping up, so maybe if you can just sort of chat in your responses, that would be great.
I'll put a poll real quick. Give me 1 second.
Okay. And I think the poll is really indicative of what I'm talking about when I talk about the community response. Here we have just a couple of examples of the people that are involved, and I know all of you are really on this webinar today because you are involved in this project that Tony talked about as she introduced us. And so hopefully that sort of idea of a coordinated response is not a new one to you, and don't want you to get sort of also deaf to that, because we really do want to have a robust coordinated response in actions, not just in words, right? Let's see. Okay. You know, I think I'm just going to go on, and we've got a lot to cover, so I'm sorry about that, guys, and hopefully we can fix that later.
We can go back. It'll be like 5 or 10 seconds.
Okay. Okay, so now you guys should see the poll on the right-hand side of your screen, and you can just indicate by choosing the circle next to what you are. Okay, hopefully you guys have had time to submit your answers. We're going to move on. So today, what I do want to start off with is this idea of foundationally, what is our mission, right? And that's everybody that's involved in the system. The mission has to be that we are going to be victim-witness-centered and offender-focused. So let's break that down just a little bit. When I say victim-witness-centered, what do I mean? I really mean that we need to recognize that victim witnesses are central to our criminal justice system, right? They're not some ancillary thing that we just need to do our job. They really are central, and that these crimes have impacted them in ways that we don't even really understand sometimes, right? The trauma that can be involved and the really complex responses to these complex homicides. And so we always have to start with that idea that, you know, we are not central to them. You know, let's be clear about that, right? Their lives are full of other worries and responsibilities and priorities, and they are central to the work that we do, but it doesn't really work the other way around. And so what we should always be doing is making sure that while we do our jobs, we are constantly thinking about victim-witness rights. Are they safe? Are we protecting their privacy to the extent that we ethically can? And are we thinking about all of our decisions and the impact that our decisions have on their well-being? And that really needs to be some paramount concern for us as we do our work. And then the opposite side of that, right, the other, not so opposite, but the other thing that we're really focused on is the offender, right? That's what we want to make sure we keep the narrative really pinpointed, to keep the focus on what did the offender do? Who is the offender? What was the offender's intent, right? Because we know that offenders take advantage of situations where they think they can get away with it, right? Where they don't think they'll be held accountable. And you'll see that play out in different ways, whether that be in a sort of domestic violence homicide, or in, if a homicide's occurring, you know, out in broad daylight, but in a community that has so much, perhaps, distrust of the system or fear of the offender that they aren't going to want to participate. And so offenders know this, and they're taking advantage of that. And ultimately, all these issues that we see, all these complexities, this aftermath that occurs after a homicide, that's who's responsible, is the offender. So even when we have perhaps a victim witness that seems to be frustrating our work, we have to remember, hey, this is a small part of their lives, and they need the witness victim is taking care of themselves. And the offender is really the one that's responsible for this frustration that we may be experiencing, not the victim witness. So when we talk about complex homicides, and you guys know this because this is your project you're all working on, the four major pieces are that intrafamilial homicide, the gang-related. We'll talk about child witnesses, and then impaired driving, which I'm really not going to touch on today in any sort of specificity. So why are these cases so hard? Now I have here, to type your answer into the chat box, and I'm going to invite you to do that. But it looks like our sort of interactive piece might be a little off today, so I don't want to spend unnecessary time doing that. But I want you to think about it. Why are we here having this webinar? Obviously, this is an issue that you guys are coming across in your work, and there's a variety of reasons that you may identify with what you're seeing in your communities and your jurisdictions. And just a small sampling of ideas that make these cases hard. I sort of touched on that idea that these complex homicides may be happening in communities where there is a historical present mistrust of police or fear of the perpetrator. And of course, that can be like a community fear of the perpetrator, but it could also be because there is some sort of relationship between the victim witness and the perpetrator. Or this belief that, nothing's going to happen, nothing's going to come of this. This happens all the time in my community and nobody's ever held accountable. And that kind of dovetails with that mistrust, but it's almost sort of like giving up on that. Why am I going to put myself out there? And then this fear of arrest or deportation. I'm going to touch a little bit on the fear of deportation and sort of a response that we may be able to have that can alleviate that fear. And then because we are talking about intrafamilial homicides, all those domestic violence dynamics, and of course that can be a day-long training in and of itself, but we know that those dynamics include, the complex ideas of love and fear and wanting to keep a family together, and all of that can play into it as well. You may have an anti-snitching atmosphere that's happening within these communities. And you may also have victim witnesses that really don't have any idea that there are services out there available to them that they can tap into. So just touching on a couple of ideas there. And then to really touch on the fact that this is complex, and depending on the type of case you're working on, you may be dealing with a victim witness who has experienced not just the trauma that we can immediately sort of think about when someone witnesses a homicide, but they may also have those competing dynamics of grief and love if the victim is close to them, or even the perpetrator is close to them. We have this extra layer here. So now that we've sort of touched on why is this complex, let's talk about some strategies of how we can respond in perhaps a more effective way. And the two kind of pieces of this that I want to focus on is, number one is, can we respond in a trauma-informed way that is going to provide victim witnesses with services, alleviate some of those fears that we touched upon, and put victim witnesses in a place where they feel they can participate in the system with us. And then the second one is, we know that witness intimidation is happening, and then how can we sort of mitigate that? How can we respond to it? So trauma-informed, what does that mean? From a very basic sense that we're talking about recognizing how trauma has impacted witnesses. And in some cases, this could be historical trauma. It could be systematic trauma, and it could be the acute trauma of the homicide that sort of brings them to you. So we've got to think about it as sort of a broader issue that may be, how they were raised, what kind of community they come from, what other sort of traumatic experiences they've had in their lives that then color how they respond to this one that's bringing them to us. And then we've got to implement a response that considers that impact. And so a couple of things we want to touch real quickly, and I've added a great resource at the bottom if you want to learn more about trauma. But for our purposes today, I think the takeaways are that it impacts every aspect of victim witnesses' lives that have experienced trauma. So it's not just something that's compartmentalized. It can impact eating habits. It can impact romantic relationships. It can impact health, physical health, mental health, and it can lead to common reactions. There's no blueprint for like how trauma looks in one person versus another. There's a lot of variety, and so it's good to know what some of the common reactions are, but I wouldn't want you to think that that traumatic responses are limited to these things. I put these here because these are probably some of the things that impact our work the most, but common reactions are delay in reporting, right? Someone that doesn't want to immediately go to the police, or someone that when giving an initial statement may not actually report the full truth of what they had experienced. And that goes into that sort of minimizing, and that's a physical, sort of neurological response. Our brain is part of that, to minimize that trauma and try to make ourselves safe. And then the other response is, okay, part of making ourselves safe is we're not going to participate in this. There may be a refusal to participate. And then you may even see the recantation and testimony on behalf of the defendant. We see that a lot in the intrafamilial homicides and related cases. So one of the things I want to have you guys look at is, are you working in jurisdictions where our responses to sexual and domestic violence cases may be a little bit more robust, right? They may have been using these words, victim-centered and trauma-informed a lot earlier than some of our other units, whether that be specialized prosecution units or units within our police department. But can we look towards what has been going on in those units to inform what might work in these complex homicide cases? And so some of the things that we look to is that number one is that connects the victim witness with an advocate. And timing is so key to that. The research when it comes to domestic violence shows that if the victim is connected with an advocate basically on the scene, there's a much greater chance that the victim will actually engage with that advocate and continue and receive services. So that immediacy of that, making that connection, is really, really key. Then it's providing services, right? We talked about one of the complexities being that victim witnesses have no idea what's out there for them. So can we provide them with services that can help them respond to their trauma and maybe even help them with some other, necessities that they may have because of their victimization or because they were a witness to this crime. And the last piece, and it's really so key, is having consistent contact with victim witnesses. I think we tend to sort of have that immediate response. We want to do the investigation, and then there's a lull. We know how the criminal justice system works, right? There's sort of lulls that happen as we're behind the scenes putting together our cases. And a lot of victim witnesses will tell you they have no idea what's happening. And that idea of not being informed, not having that constant contact, you're going to lose participation along the way. So can you formulate a plan to provide that constant contact? It doesn't have to be the prosecutor every time, the law enforcement every time. Really tap into the service providers and advocates that you're working with to help you do some of that consistent contact, because others may not have the time and that's not their primary job description. But if no matter who does it, if we don't do it, we're gonna lose victims and witnesses. So the responses that I want to sort of hone in on with a little bit more specificity is child-specific services and strategies, trauma counselors, this idea of keeping the witnesses informed, immigration relief, and then confronting witness intimidation. So with the response with child witnesses, you know, there are, number one, tap into what you may already have within your communities, a child advocacy center or some sort of specialized center, usually employing forensic interviewers, that have specific training to conduct interviews for with children. So these are age-appropriate interviews and they're trauma-informed interviews. And so there's a specific skill and education that comes behind these forensic interviewers. And I think a lot of people are used to using these CACs or child advocacy centers in the context of child abuse cases. That's how, you know, a majority, I think, of cases that come through CACs are kind of through that vein. But we would be remiss if we didn't tap into that expertise to help us respond to cases where there are child witnesses. I know there's just sort of this idea that if we can go forward without this child, we want to, but I think we're missing a real opportunity to provide not only that trauma-informed interview, that age-appropriate interview, which hopefully will help us because, you know, those are typically recorded, and oftentimes those interviews themselves are admissible in court, and you could really prevent the child from having to come in to testify under certain legal requirements. But also these CACs often are equipped to provide ongoing counseling for children. So if you sort of don't bring the children in for that interview, you may also be losing the opportunity to provide the child and their immediate family really with that trauma-informed response that's so key, right? So to provide that counseling and other services for the children that may have witnessed these violent crimes that, you know, when children are witnessing, that's often because it's an intrafamilial homicide that we're talking about. And that goes back to those layers of complexity, the grief and the loss and the love and the trauma. And so I really encourage you to tap into that resource. And then when we're looking forward and thinking, okay, are we going to have a child testify? Number one, we may be able to eliminate that testimony altogether if we've got that forensic recorded interview in your law. Again, this is sort of very state-specific responses, and Equitas can do the research for any of you out there that are curious about what your particular jurisdiction might say about this, and so please reach out to us. But even short of that, when a child does maybe need to provide live testimony, are there ways to ask for accommodations? And this is not unusual in the courts, and hopefully your courts and judges won't think this is too out of the box, because I think we've been doing it in the child sexual assault cases for a while, but there's opportunities to testify via closed-circuit TV, so the child isn't in the same room as the offender. You can ask the court to allow for a courthouse dog. If you're lucky enough to have one, there's such wonderful, wonderful resources. Or a transitional object, and that's the term of art used to have a child, you know, have a teddy bear with them, have a baseball glove with them, have something with them that they sort of tactilely can bring to the witness stand. There are also precedent to have the courtroom rearranged so the child is not walking by the offender or not directly looking at the offender during testimony. You can ask the court to order the defense to raise his or her hand to make an objection instead of that really sort of aggressive, you know, stating out loud version. So that there's some language that can be used to ask the court to do that. And again, a good opportunity to reach out to Equitas for that. And then when a defendant is pro se, and we see that, you know, on a fairly regular basis, the defendant is representing themselves. Can we avoid them cross-examining our child witness? And there is great case law that says we are not limiting the defendant's right to represent themselves when we appoint special counsel for the purpose of that type of cross-examination. Again, if you need any more details on these, because they are state-specific, we can help you with that. And then this is just a case out of the U.S. Supreme Court that we usually use to sort of establish a lot of these ideas about accommodations for witnesses that come out in 1990. And it says that confrontation clause, that that clause in the Constitution that says the defendant has a right to confront witnesses against them. The Confrontation Clause does not categorically prohibit child witnesses in child abuse cases from testifying against defendant at trial outside of the defendant's physical presence by one-way closed-circuit television. But the court must make a determination on a case-by-case basis. So this is saying, yeah, the child can testify via closed-circuit TV, doesn't need to be physically present to have that right of confrontation held up. But it's a case-by-case basis. So what does a prosecutor need to do? They need to file a motion in advance of trial. Oftentimes, that motion is going to be accompanied by some sort of expert or medical testimony saying that there's this likelihood of trauma to the child should the child be in the presence of the offender defendant. And then this is something that should be obviously handled pre-trial outside the presence of the jury and in enough time ahead of trial that you can then make any accommodations necessary that the judge is ordering. And I've provided a resource here that has a lot of great information about making courts safe for children. So trauma counselors. These are specifically trained to respond to victims of trauma. This is sort of outside of just children witnesses, but any of your victim witnesses, right? In Miami, we had trauma counselors on our staff, and I would say, I don't think it was necessary, but most of our trauma counselors had actually also been impacted by homicide. So we would call them colloquially like homicide counselors. And they were then able to work with families, with victim witnesses, and not just be able to sort of go through the checklist of, hey, here's some services, here's some resources, this is what we need, this is what we can do, but also really connect and say, I've been impacted as well, and this, I understand what you're going through. And also, a lot of them will have participated in the criminal justice system as a victim witness, so they can share their experiences with that. And most people that have participated in a prosecution will say that testifying and that has been a positive response, and so they can kind of share that. And they can be employed by different people within the sort of coordinated response. And then this key that I want to keep going back to, which is keeping the witnesses informed. Number one, victims often will have a victim's bill of rights. Majority of states have passed some form of victim bill of rights, and that the first one is often this idea of keeping victims informed, that they have an absolute right to know what's going on at any critical stage of the prosecution. But I would sort of ask you to expand that and say, not just critical, don't think, okay, that means I just need to tell them about the trial or I need to tell them if a plea is happening. The mystery of our system is really broad. People are very confused and they don't understand why there are these long gaps between hearings or what happened at some hearing that nobody needed to be at besides the judges. Like, take the time and explain this, right? They're going to be more engaged when they understand the process, and you can also sort of manage expectations, right? You can let victim witnesses know early on, this is going to be a long process. This isn't going to be over quickly. We're going to be here with you through the long haul. If you have any questions as things come up, please let us know. Because most victim witnesses, if they are engaged, are going to be checking that online docket, and they're going to see something happening, and they're not going to have heard from you. And that can really sort of break down any trust and rapport that you have built. And it probably was, a hearing on resetting a date for something, and you're sitting there going, oh, the victim witness doesn't need to know about that. But because of that online accessibility, it's even more important that you're explaining the system along the way in all those various states. And then also when it comes to trial, being able to explain the trial rules, like why a victim witness can't be observing the entire trial, where there is sequestration of witnesses. That might be something completely unexpected that can really throw a victim off if they're not really understanding how that works. So leading up to trial, I would even spend more time, if possible, having them come over and view the courtroom itself, and for children witnesses, that's really key. But I would say even for any witness that's just unfamiliar with the system, like this is where people sit, this is what it looks like, this is what how you're going to walk in, and who's going to give you the oath where you're promising to tell the truth. And I have to say, I was a witness in a homicide case. I witnessed a homicide while I was in law school, and 5 years later I came back and testified at that homicide case. And it was a courtroom I'd never been in, and it looked very different than the courtrooms that I was used to in Miami. And it was intimidating to me on really a lot of levels, and it taught me a really important lesson. And so I spent a lot of time with witnesses and victims. Even if I can't get to the courtroom with them, I'll draw something out for them and really spend some time. So promising practices for all of this is that vertical prosecution, which means that if at all possible, can the same prosecutor be handling the case from beginning to end? So you're not having that hot potato style of prosecution where a victim witness may not really know who's who and who's handling what. If you can have that consistency of the vertical prosecution, that's a wonderful way to keep that rapport, build that rapport with any victim witnesses. You know, determine that best means to communicate. I know we were employed with a bunch of great employees at the state attorney's office. Their job was to, you know, make calls to victim witnesses and make sure we had their correct address, make sure they knew about any upcoming court dates. But as we've evolved in our means of communication, that sort of landline to landline style of communication was just ineffective, right? So is there a better way for us to communicate with our witnesses? And even if we are required to still do that sort of telephone call, which is getting such an ancient means of communication, can we make sure that we have a good telephone? We know that, in my experience, victim witnesses would often either change phone numbers a lot, right, because there's that intimidation happening, so they're changing phone numbers. They may be doing a prepaid cell phone, so they're running out of minutes at certain times, and so the phones would not be in service for a while. And so what I'd always ask is, is there somebody that has a landline? My line was always, you know, your grandmother. Can I get your grandmother's phone number? It could be you know, some sort of friend. It could be a family member. But can you get that next best contact so you have multiple sort of levels of ways to get a hold of your victim witness? And then provide them with the phone number, contact information of their point person. And that can be, sometimes it's the lead detective. Sometimes it's, you know, your prosecution office victim witness counselor. Sometimes it's they're more comfortable with a community-based service provider, and you've got that relationship. That communication can go via that way. So, but just figure it out, right? Who is that point person? Who's most comfortable? Who's going to be most consistent? Because that consistent contact, it builds the trust, it builds the rapport, it keeps witnesses informed, it allows us to respond to any ongoing needs, because those needs are going to change, right? As these cases, complex homicides, you know, we're talking about years to the end of prosecutions, in my experience. And so there are ongoing things that are coming up, and we can better respond when we're having that consistent contact. And then that other key part is we can identify witness tampering via consistent contact. And part of that is, well, if we have consistent contact and then all of a sudden we're losing contact, that should immediately give us a red flag, so we should start thinking about, okay, tampering, intimidation may be happening, how can we be looking for it? So I'm going to bookmark that for a second, quickly talk about immigration relief, and then we're going to spend the better part of the rest of the webinar talking about witness intimidation responses. So immigration relief. If you're working in a community where there's undocumented refugee victim witnesses, that's going to be a major challenge, is that gap there, right? Victim witnesses not wanting to sort of come out of the shadows and cooperate with police investigations. And so the U.S. government has recognized that in response to that, because of the identification of, we want to have eyes and ears in those communities. We want to have eyes and ears on those offenders that are perpetrating crimes against the most vulnerable people in our communities. There are a couple things that can be done via immigration relief for victim witnesses of certain crimes. And this is, again, you know, a whole training in and of itself, and I really invite you to reach out to Equitas. We do a lot of work with the National Immigrant Women's Advocacy Project, or NUOP, and they have a great library that's referred to on this slide. Two major things that I think could come up in your cases is the number one is deferred action. This is really discretionary and almost sort of an informal way to keep a victim or witness in the United States that otherwise would maybe be subject to deportation. So it takes a direct request from law enforcement. They have to contact their local United States Citizen Immigration Services, or USCIS, and say, hey, I'm working on this case, I've got this victim, and I want this victim to stick around while I'm investigating. And they can give what's called a deferred action, which basically delays any deportation proceedings until the case is over. This is not a great safety net for victims because it is so discretionary, it's a little informal, and it doesn't provide any additional resources with it. The other more formalized immigration relief that may be available is the U visa. And we typically see this in the context of victims of domestic violence and sexual violence, but there is a whole slew of qualifying criminal activity that's listed out. If you are a victim of any of this qualifying criminal activity, you may be able to apply for a U visa. And that includes witness tampering. So it's domestic violence, sexual violence, witness tampering, kidnapping, a lot of violent crimes that you can imagine. So it really is made for victims of crime, but there are certain circumstances where witnesses may apply if they were so directly affected by the crime. So witnesses may apply under the U visa under very limited circumstances, but a lot of times the witnesses are going to sort of be also victims, right? And especially if there's witness tampering and intimidation happening. So these, what we may be calling witnesses under the U visa rubric, they may be able to apply as victims of witness tampering. So again, lots of information here, but just good to know that there is some relief that's available that you may be able to say, hey, I'm working with you as a victim, witness, I know you are, you know, unsure about participating with me, you've got these fears going on, let me connect you with some appropriate people, which may include like an immigration attorney or immigration services in this case. So now let's talk about witness intimidation and where it comes from. And we know that it can be the offender themselves, a lot of times it's the offender allies of the offender, it can be happening within our communities, it can be happening online, and it can be overt. You know, I always talk about the Godfather, the horse head on the bed. You kind of get the message real quick there, but it can also be really subtle, right? And in intrafamilial homicides, I think that's where you'll see that subtle intimidation that really looks like emotional pleas rather than threats, and that also counts as witness intimidation. And these gaps in our community's responses, so right, the community response and the gaps, that's really where the victims fall through and the offenders crawl through. So this idea that we're allowing the offenders to take advantage of these gaps and our victims are falling through when we're not doing our best to sort of close these gaps. And so the challenges that we're facing, number one is we've got to reduce the opportunities to intimidate, right? So where can we look for these gaps and how can we close them in an attempt to just reduce any opportunities, right? And a lot of it comes from educating victims, educating witnesses, what they can expect, what it's going to look like. Maybe they aren't seeing it as intimidation when it's coming as an emotional plea. They're not identifying right away because they don't have, you know, the horse head or the in their bed. And then preserving the evidence of intimidation. This coordinated response is so key, and oftentimes it's unfortunate, but we're asking victims to do a lot of the work here. And so they need to be educated not only on what it looks like, but how they can preserve it and what they should do with any of the evidence they may receive. And then we need to have, as the community and as the prosecutor in particular, we need to be charging intimidation crimes. We need to be investigating them robustly. We need to be charging them, and then all that evidence we need to be using effectively, whether it be in trial in the case in chief or under the additional charges. So reducing opportunities, and this can look like safety planning. I also sometimes hear it more like a threat assessment, but the idea is the same, which is that we're spending time with our victim witnesses and we're identifying potential vulnerabilities. And that can be anything from location, where do they live, where does this happen, what kind of neighborhood, do they have mutual acquaintances? Obviously, if they're family members, then we know that to be the case. Are there connections on social media? Who has their phone number? Which way do they walk to work in the morning? Where do their kids go to school? All of those things should be sort of gone through in detail to make a safety plan so that we can discuss ways with victims how to keep themselves safe. And then consider safety provisions that can be implemented within the criminal justice system. So what am I talking about there? Well, here's a couple of quotes that say, you know, most explicit acts of intimidation take place where police exert little control. So they happen at the witness's home, school, or work, or while the witness is running errands or socializing, right? So we know that we can close the gaps a lot easier if we're talking about, you know, intimidation in a courthouse or intimidation in a police station or intimidation outside of some sort of hearing. But it's during in these other areas where we have less control, where the safety issues need to, unfortunately, we need to be talking about witnesses how to keep themselves safe, because we do not have, you know, a shield that we can put around all of our victim witnesses at all times. So we need to do the best we can by using some simple strategies and then sort of escalating from there. So witnesses can also report being intimidated at the crime scene, while at the station, and while at the courthouse. And so we can't lose sight of that either, that within our control, we should be doing the best we can. So when witness tampering and intimidation occurs, we can be occurring during the investigation. So thinking about, how is the police station set up? Is there a way to bring a victim witness into a police station where it's not going to be really observable to others? Or maybe we're in a big enough city that that's not as big of a concern. Or do we have multiple witnesses in the police station at the same time taking multiple statements where we don't really have a clear idea of who's an ally with whom? Can we limit that and make sure that we're not doing that, and that we're having our victims come in and they're the only one that's coming in the station at any given time? Same with the prosecutor's office. When I would you know, have a new case and I'm bringing in the witnesses to have my first conversation with them, I'm not bringing them all in one afternoon where they're going to be in the elevators together talking outside my office together, right? A, that's not great for my case, but B, I don't know necessarily what the dynamics are going on. So if I can schedule those, you know, days apart so I can limit any interaction. And then the grand jury is a great tool, investigative tool, because there is just all this privacy and secrecy that's going around a grand jury. So can we get those statements taken in a grand jury where we have that ultimate privacy of our investigation? And then during our discovery in our pretrial phase, let's use redactions so that we're using initials, we're not putting in home addresses, social security numbers, phone numbers, schools that their children attend, or schools that the witnesses themselves attend. So I think we initially just think about redacting names, and I'd say go a little bit further and really think about any identifying information that somebody could sort of take and figure out, okay, this person is somebody that works in that neighborhood and has a daughter that goes to that school. Well, I know who that is. So really be a lot more sort of thoughtful when you're making your redactions, and be ethical in that at the same time. Use of initials and pseudonyms kind of go into that. And then the protective orders. So the protective orders is sort of two pieces. One of that is, are there certain pieces of discovery of evidence that I can ask the court to keep under seal, a search warrant, perhaps an arrest warrant, where I'm really outlining all my witness statements. Can I keep that under seal? And the other one is, can I ask the court to issue a protective order, or we would call it a stay-away order, where the perpetrator is not to have any contact with any of the witnesses or victims in a case. Yeah, it's just a piece of paper, but if you implement a vigorous enforcement of that, you can start cutting down on intimidation, because the benefits of intimidation are not being seen by an offender who keeps getting sort of new charges added on. At trial, think about how your victim witnesses are transported. If everyone's coming on public transportation, a lot of courtrooms are very public transportation accessible, right? That's a good thing. But if that's how your victim witness is typically going to transport themselves, can we have somebody else transport them? Within the courthouse, are there soft rooms or rooms where we can hold witnesses so they're not out in the hallway and they're not having that constant contact with the defendant or defendant allies? And then within the courtroom itself, put everyone on notice. Have the bailiff be your eyes and ears in the courtroom. Have the judge know that this is an issue, so that they're on top of it and they're looking at whether people are taking pictures or making any recordings. Depending on your jurisdiction, can they limit that? And because as a prosecutor, when I'm in court, when I'm in trial, I'm sort of laser focused on what's happening in front of me, and this intimidation is mostly happening in back of me. So I need another set of eyes and ears in there. And your advocates that might be in the courtroom, your law enforcement officers that may be allowed to be in the courtroom during trial, they can also help with that. So any of those protective orders, those court orders, they would need to be really carefully worded. They need to be really comprehensive about what no contact means. Right now, these days, that means you've got to address the social media concerns, third-party contact, and then if there has been a history of intimidation, you know how that intimidation came about, then you can put in some specific language for that. For example, you can add in, instead of just saying work or school, you can add in specific addresses, or you can add in like a mother's house or something like that. And it really, the ultimate piece is that it needs to be enforceable. And so in the courthouse, we're posting zero tolerance notices. We're advising everybody. We've got our safe waiting rooms and perhaps the escorting and, again, restricting the use of the cell phone. And then the educating the victims, I really think this is a really key piece of it. Number one, it needs to be done at every single contact because offenders will change the way they intimidate or they try to tamper with witnesses. What they might do at the very beginning of a case might be very different than how they address this in the middle of a case, and then again, at leading up to trial, it might start getting heightened. So if you have this sort of comprehensive conversation right at the beginning where this victim witness is in the midst of this acute trauma, they've got so many things whirling around their head, you're talking to them about witness intimidation. It's all kind of information overload, and then 3 months later, things have calmed down and they get a Facebook message. They may not connect that with what you told them at the beginning. So this has to be a consistent conversation that you're having. You've got to be asking victim witnesses pretty pointed questions about any contact they may have received. Explain it's going to be happening in various forms, and then provide the tips on how to preserve evidence of tampering. Tell them about how to take a screenshot or have someone else take a picture of a phone or record a voicemail, or just alerting you that they received a phone call that had that jail recording at the beginning, or we still see, people getting, handwritten letters and cards. And then advise the witness to contact their point person immediately. This is, the caveat here is obviously that 911 should be called first if there's any imminent danger, but then also having that backup point person so that they know that if they're not disturbing, let's say, the lead investigator on the homicide, they may feel more comfortable, talking to some sort of advocate and say, hey, I just got this weird message. So that can be really helpful. This is a resource. Denver is doing some really amazing work when it comes to witness intimidation. We work with them on one of our grants. This is one-sheeter that they developed. It really is geared towards domestic violence victims, and basically it's sort of telling a victim, hey, this might happen to you. This may be what it sounds like, right? These are some words that you may hear. And so the idea is that a victim can read this and be like, oh, okay, and then, you know, a month later they start hearing, you know, I'm going to get sober. It was just because I was drunk. You know, don't let this ruin our relationship. And all of a sudden that victim would be like, I was told you were going to say that. And so this is a one-sheeter they developed. This is the second half of it, and the unfortunately it's a very long hyperlink here, and hopefully you'll have access to these slides later. But I think it's a great thing for us to be looking at, and then to think, okay, how can I maybe take this idea and develop something that really meets the needs of the work that I'm working on. And I did something very similar to this for our human trafficking cases in Miami. So what are the signs of witness intimidation? And I'll clue you in. It's E, all of the above. So witness intimidation, oh, sorry, I think they got the poll there. The witness recantation, lack of witness, lack of contact, and a speedy demand being filed. So the C was a little bit of the wild card there. So obviously when we've got a witness that's been saying something the whole time and then all of a sudden recants, big red flag. We've got a witness that, you know, we had contact with, even if minimal, and now all of a sudden we don't have any contact with. Red flag, maybe we should be reaching out to friends and family. Maybe we should see if they've been accessing services that we connected with them. And the speedy demand filing, that's just from my personal experience. You know, somebody would be delaying, and then all of a sudden the defendant wants to go to trial immediately. Wonder why all of a sudden they want to go immediately. It was always a big clue to me to see what was going on, because they knew more than I knew what was happening with the witnesses in the case. So only unsuccessful intimidation ever comes to my attention, right, your attention. If the intimidation works, then we don't have a case, and our case kind of disappears. So how can we kind of fix that? Number one is preserving that evidence. Where are we looking for it? I think probably a lot of you on the call already know that jail phone calls are like a little treasure trove for us. So can we have a proactive, a lot of, you know, jurisdictions are now very proactively monitoring jail phone calls, probably, you know, prioritizing based on some threat assessments which calls they're going to listen to. In Miami, we did it very reactively, which was not the best, but still gave us lots of good evidence. Jail logs, you know, people might be visiting somebody in jail, sort of trying to avoid that recorded jail phone call. Instead, they're going and visiting, but they need to provide ID, and we can see who's coming and going. Looking at social media, whatever's public source, social media, witnesses, friends, and family. All of those are ways that we can be connecting and trying to preserve this evidence. And, you know, can't say it enough, it takes a coordinated response. Service providers usually the first one to know, and so that's key to letting us know, because then the law enforcement piece has to get triggered so they can initiate an investigation into it, and then the prosecutor's got to be brought in to try to enforce, whether it's enforcing a protective order, asking for the defendant to be held in contempt for violating that order. Maybe there's a separate charge for violating a protective order. Maybe this is tantamount to whatever your legal definition is of witness tampering or witness intimidation, or there are forfeiture by wrongdoing, which is a legal concept I'm going to talk about in a second, and then also just it's evidence of guilt, consciousness of guilt. We can bring that in our case in chief. Why are they trying to get this person not to testify if they're innocent? Great case law to the effect of that. So, you know, relocation is it's a big topic, and I don't have great news for everyone, I have to say. In a state-based system, there aren't a ton of resources to relocate our witnesses, but we should be looking at whether we can provide or at least sort of go through some options with our witnesses, and that can be talking to a victim witness about, hey, can you temporarily stay with friends or family? Do you have someone that you can stay with? And that can be during the investigation, or maybe that's just during the trial. But we can also sort of tap into some funds that we may have to temporarily relocate someone, in a hotel during an investigation, hearing, or a trial. And usually there are funds that allow that. I know we used it for, out-of-state victims and witnesses that were coming in to testify. We put them up in a hotel during that time. That same sort of funding can also fund a local witness to have that temporary relocation. That's usually coming, in my experience, from the police department and from the prosecutor's office funding. Now, when we're talking about sort of longer-term relocation, the most success that I had, frankly, was partnering with our housing authority. So a lot of the victims and witnesses I worked with had Section 8 housing. And so and we were able to partner and have them relocated within the county and even out of county by partnering with different housing authorities to make that happen. And I had, sometimes all it took was a letter from me, but I also, had some phone calls and sort of trying to get through that bureaucracy. But overall, that was a positive response, and I feel like if you developed that partnership early on, then you could keep tapping into it instead of having to sort of rebuild that relationship and have that conversation on a one-by-one basis. If you just bring the housing authority into maybe a coordinated response meeting or have them come in and meet with you guys on occasion and sort of say, hey, these are the issues that we're seeing, what could we do to really help relocate victims, witnesses within our communities or even past our communities, depending on how your jurisdiction is set up, your state system, if it's on a county or statewide system. So that's really the thing that I would say was the most successful way that we were able to relocate someone. But there's also victim compensation funds that you should be tapping into. And I've given the link here, National Issues of VOCA Assistance Administrations. I'm guessing OVC probably has even more insight here. But thinking about these compensation funds, could they cover relocation costs? So you can provide victim witnesses with that resource and say, yes, if you want to relocate, again, it's sort of a more informal basis, but we can cover these moving costs. And we do that for our domestic violence victims. So again, thinking about what is our system already doing and how can we tap into that. And then developing a formal witness relocation program. So the gold standard is the U.S. Marshals program. And I know of, and we do some projects on witness intimidation, and as we know of it right now, there are no states or local programs that sort of match that gold standard, but there is a real push to start developing one. So I mentioned Denver being sort of a leading jurisdiction in this program. They are working on developing a formal relocation program, excuse me, and they do things like provide a new identification for victim witnesses. So I think that's sort of the longer term, looking down the road, is that something that you want to develop, and how, and then maybe connecting with some agencies that are already doing that or thinking about doing it. But again, sorry that I don't have better news to tell you that there's this mystery fund out there that we can use to relocate all of our victim witnesses. But we should, the takeaway is we should be taking our victims and witnesses' fears seriously. We should be doing those threat assessments, and we should be responding in a trauma-informed manner. We should be thinking about, okay, what can we do to make you safer that's short of relocation? And that can be everything from, can we use our funds to change somebody's locks, to put on some security measures at somebody's house, all sorts of things short of that, right? And then can we, longer term, connect victim or witnesses with lifestyle-changing resources that will allow them to make real change that can keep them safer long term? It can be educational, that can be job training, that can be the sort of idea of moving someone out of a neighborhood. I think there's real complexity here, and I know this is a major challenge. Hopefully there's a couple of things that you could implement right away, but I'd also say this is a place where there's room for any jurisdiction to really develop a more robust response. So now what, right? So if the intimidation did not work, so you've got a victim witness telling you about it, right? Hey, this is what happened. So then what do? We charge that as criminal activity. We charge witness tampering. We use it as 404B evidence. Basically, that's evidence of crimes outside of a charged crime. So defendant's on trial for murder, and we ask the judge, hey, not only do we want to talk about the murder, but we also want to talk about this 404B evidence, which is this intimidation, this tampering that occurred. And then it also is just evidence of consciousness of guilt. Hey, we want to be able to talk about the fact that he's intimidated witnesses because that's relevant to whether or not he committed the crime, consciousness of guilt. If it did work and now we don't have a participating victim witness, now what, right? So we've got to make sure we're doing a robust response. We can't just throw our arms up in the air. Excuse me. We've got to gather all the evidence we can of the tampering, and then we need to litigate forfeiture by wrongdoing. I'm going to tell you a little bit about that in a second. And then proceed with an evidence-based prosecution, which means, hey, we're going to go ahead. We have enough evidence. We've done enough of an investigation. We have enough statements that we can admit that we can still go forward with that prosecution. So what crimes are we charging? Witness tampering, intimidation, a violation of criminal or civil protection orders, and contempt of court. You may also have a case where this level of tampering rises to like a stalking. So look at stalking as well, and I should actually have that on there because especially if there's multiple violations of a protection order, that kind of can bring it to an additional felony, and stalking charges can be appropriate. Oh, and the other thing I was just going to say real quick here was contempt of court. It seems kind of maybe a little silly. I don't know what your experience was on it, but we started using it in Miami, and it really was great because, A, it's very quick response in the sort of, you know, in comparison to other criminal justice system responses. You can file a petition for order to show cause, sort of gets the contempt of court proceedings initiated, and then the contempt of court hearing is really just the judge and the evidence. There's no jury, which is helpful in just moving the process along, right? So typically a contempt of court is only punishable for up to 6 months, but you can get multiple contempts of court and they can be sort of stacked. And so you've got an offender that keeps getting, if they keep violating, they can get multiple 6 months of incarceration, whether they're pending trial and they were previously out of custody or whether they were in custody, it can be tagged onto any sentence. So using the evidence, right? Probable cause for additional crimes that can be joined with original charges. So now you've got a defendant that's not only on trial for homicide, but they're on trial for homicide and witness tampering. All that evidence comes in, really makes our case a lot stronger. And then we can file the other crimes evidence and establish forfeiture by wrongdoing. So joinder is the rule that says that we can join separate offenses when there is this, when they're based on the same transaction or they're connected with or constitute parts of a common scheme or plan. So that's the rule that allows us to join different charges even though the homicide happened 6 months before the witness tampering happened. It makes our cases stronger. Here's that other crimes evidence, that 404B evidence. That allows us to bring in evidence of other crimes when it shows motive or opportunity or a plan or absence of mistake. But it's also admissible to show consciousness of guilt, which it can be like fleeing from a scene is a really typical way to do that, but intimidation and tampering can also work there. It can also be admissible to show why a witness has the fear that they have that may explain why they maybe delayed reporting, why they minimized an initial report, why they became uncooperative for a while. All of that can kind of explain sort of those traumatic responses that our victims may be experiencing that a jury doesn't quite understand. Forfeiture by wrongdoing, it's really a legal concept that really makes common sense to most of us, right? It comes out from 1666. From the United States, it comes from a case Reynolds v. United States in 1878. It was a bigamy case where the defendant had two of the wives testified in the initial court hearing. He was found guilty. It went up to the U.S. Supreme Court, lost on an argument of freedom of religion, came down, reversed on something else. They needed to be retried. At the retrial, one of the wives, the defendant had sent one of the wives out of state so that they couldn't get her into court. So he said, Reynolds says, hey, you know, I have a right to confront my witnesses. Only one of the wives is here. The other wife, you didn't get here, so I should be free to go. And the court said, no, you're the one that sent her to another state. You now can't complain that you don't have the right, that you can't confront her. Hopefully that makes sense. It's really a rule of equity. So it's like, what's fair is fair. No jurisdiction has rejected this legal concept. Many have codified it. It's included in most states' rules of evidence. It's also included in the federal exception to hearsay, Federal Rule 804, and it basically says that the statement is not excluded on hearsay grounds when it's offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability as a witness and did so intending the result. So basically it takes a couple of steps, but the real language here is from Reynolds v. U.S. It says, excuse me, the Constitution guarantees this right of confrontation. It grants him the privilege of being confronted with the witnesses against him. But if he, the defendant, voluntarily keeps the witnesses away, he can then not insist on his privilege to confront. So really basic, sort of what's fair is fair. A couple other cases, this is just public policy, this great language here that says, if we were to allow this, it would be making a mockery of the system of justice. So here's the three parts we need. We need the witness to be unavailable. That means we can't find them or they're unwilling to testify. They have to be unavailable because of the defendant's wrongdoing. So we need to have evidence of this wrongdoing. And then we need to have evidence of the defendant's intent. We need to have evidence that the defendant did it in order for the witness not to come to court. It's a judicial determination. It's done pre-trial. The standard of proof is lower. It's preponderance of the evidence, except there's 3 states where it's clear and convincing evidence. It's a little bit higher, but both much lower than beyond a reasonable doubt. There's an evidentiary hearing that's outside the presence of the jury. In that hearing, hearsay evidence is admissible, and the judge may consider the statements themselves to make their determination. So to prove that a victim or witness is unavailable, it can be not just, not present, but it could also be a refusal to testify, feigned or real memory loss. There's a case where the defendant married the victim, instituting a marital privilege, and that was also determined to be unavailable. So there's a couple of things that include that. But really, it's just this invaluable tool because it applies to any witness that's unavailable, any victim that's unavailable, and when it's established that, hey, this tampering occurred and this tampering was intended to keep this witness away and now this witness is not testifying, it opens the door to any hearsay. So all of your police statements, all of your recorded statements, all statements to friends and family, all of those statements can come into court as non-hearsay. So really an invaluable tool when you've got that tampering that's happened that has now kept the victim away. And again, this is something that Equitas works on a lot, so we have a lot of resources, including some sample motions if you want to look to using forfeiture by wrongdoing in any of your cases. And I just want to sort of close out with this idea of we need to be looking at the bigger picture. And what does the bigger picture mean? It means let's look at all those challenges and see what we can fix, not on a one-by-one basis, but on a community level. So can we establish trust within our communities, inform the community about available services, and demonstrate our commitment to witness safety? So those are what we want to do big picture. And a couple of ideas are just, be really present in the community, engage the community, participate in community events. So identify all those community stakeholders you have, right? So whether that be your faith-based community, your community-based service providers that are providing services within the community, not just related to criminal justice system, but related to anything that's happening within a community. Regularly meet with all these interested parties. Let that communication be flowing both ways of what they're seeing within the community and how your response is. Participate in the community events, and that can be, barbecues in a park. That can be, church events. It can be speaking at schools and town halls. But really having the law enforcement and the prosecutors out there in positive light in times not in crisis. And then hold events that are benefiting the community, whether that be job fairs or expungement events. We did a lot of that in Miami. It's very popular. And the prosecutor's office hosting an event so people can clear their records really forces the community to sort of think about what our prosecutor's role is and sort of educate them that, okay, prosecutor's role is not just, putting people in jail, but we also want to be, allowing for people to have expungement where appropriate, and so that they can have a better chance of getting jobs and all that type of thing. And then this is a little old-fashioned, but when I was a kid, we used to have these fingerprinting events where you could bring your children in and have fingerprinting kits done so that, down the line if anything should happen. But those are just examples of things that you can do on a sort of bigger picture to engage the community. So when we have those complex homicides, we've maybe already established a really positive relationships. So moving forward, say apply all those trauma-informed responses that you may be doing in different circumstances, apply those to your complex homicide cases. Make sure all the witnesses and victims you work with have accessible services, are aware of the services, they can be culturally appropriate, and they can really be flexible to the needs of your victim witnesses. That will better ensure their safety and then hopefully encourage the participation within the criminal justice system. And then confront witness tampering. Look for it, educate about it, and then really use the tools in your arsenal to enforce it and to make it so that the offender doesn't see the benefits of that intimidation. And then engage with the communities outside of times of acute violence so that you have those pre-established relationships that you can tap into when you've got a situation where you need the community support to investigate or prosecute a complex homicide. So here are a couple of the resources I wanted to share with you from Equitas, our library. There's a lot there if you go online, but the things I thought most important would be the witness intimidation, meeting the challenge, prosecutor's resource, and improving witness safety and preventing witness intimidation. We also are working on a combating witness intimidation initiative, and there's more information here. There are several sites around the country that receive funding for this, and something maybe you want to think about your jurisdiction looking for as you move forward in handling your complex homicides and looking at the witness intimidation piece of it. And of course, you can always follow Equitas. We've got our social media platforms. Try to put really informative information, connect you with new research and new resources out there. And then this is just my personal contact information, so I appreciate you guys being here today. I appreciate what you do every day, and please, please reach out if you ever need some support from and you think Equitas could help you out.
Awesome. Thank you